What's up, everyone? Welcome back to another episode of DoJLife. We are getting on as Judge Emma Bliss tonight. We have a judicial panel taking place for State v. Banks. So we are hopping on to deal with that. Sorry, little SITs running around turning off the power strip for my my RGB lights I have up in the office. Oh, how's everyone's week going? Hope you're having a great week thus far. Hit that button. Get some background music playing here. Get old Emma loaded into the game here. There we are. Here we are. Here I am, baby. Are you being so loud? Stop messing with stuff. Bring it here. Where'd you take it out of? Bring me that. No, don't go pulling more out. Goodness gracious, little SIT is going nuts over here. Ah, and you're smelling an umbrella. Very good. Turn down my background noise a little bit. All right. All right, give me a second. I gotta change her clothes. Gotta put her in her court. All right, here we go. City's in dire need of a mayor. We need someone to look up. Need someone to look up to, and we need someone to help us citizens. I wonder if there's any food joints open. There is not. Well, that's problematic. You don't have to be so loud, little SIT. This is starting at 8. Let me see. City. We need some sustenance. We got one drink and one food left. Don't think that will last me through this court case. Let's see what we got going on here. Oh, check tunnels has another warrant. I wonder if they fixed court stuff yet. No, we weren't able to do the fine stuff. Hey. Hello. Nope. Doesn't look like we're able to do that yet. Well, found Jay. Okay. Let me look at... All right, so this happened last month here. Trooper Matt Winters was at 941 Buccaneer Way when I received a call from Jason Love stating that people were following him to the dock and ramming his truck. I quickly pulled my patrol car out of the nearby garage, grabbed my uniform, and attempted to get my gear before they arrived, but they arrived before I could do so. I quickly got into my vehicle and initiated a traffic stop with a gray pickup truck with two people inside, Mr. Tim Banks and Tommy Banks. I asked if they were following and ramming Jason Love, to which they responded they were not following him, nor were they trying to ram him. trying to ram Mr. Love. I was going to let them off with a warning since the storm was less than 15 minutes away. At the time, when I returned to my car to the garage, I went inside the building to get changed before the storm. Mr. Tim Banks walked in and was seen putting something in his pants, to which I responded by backing away and keeping an eye on him. When Mr. Tommy Banks walked inside, he quickly ran up to Mr. Love and proceeded to punch, shove, and then kick him, causing Mr. Love to fall to the floor. I drew my civilian pistol, pointed at Tommy Banks, and ordered him to stop beating Mr. Love, or he would be shot. He complied and raised his hands. When Mr. Tim Banks approached, I aimed my gun at him and informed him to back up, or he would be shot as well. As I was in fear for my life at the moment, having seen him stuff something into his pants. When Mr. Love got up, I ordered him to keep his gun on Mr. Tim Banks while I arrested Tommy Banks. After arresting Tommy Banks, Tim Banks continued to approach me, to which I told him that if he did not back up, I would place him under arrest as well. I told him that he would be free to go if he entered his vehicle and left the scene, to which he seemed to comply at first. However, shortly after he went around the corner, I heard the door to his truck door open and close, and I drew my pistol once again. When I saw him come around the semi-trailer, I noticed he had something in his hands. I aimed my gun at him and told him to back up and drop the knife, or he would be shot. He responded by putting it away and continued to walk closer to me. I ordered Mr. Love to place Mr. Tommy Banks in my vehicle while I approached Mr. Banks and put him in cuffs, and ordered now Trooper Jason Love to put it on a uniform I had in my trunk and go on duty to assist me in booking process. After returning to the station, I searched both of them, found 13 bottles of prescription oxycodone and one switchblade on Mr. Tim Banks, and found both Tommy and Tim Banks' IDs on Mr. Tommy Banks. After reading Tim Banks his charges, he informed myself and Trooper Love that he wished to plead not guilty. Mr. Tommy Banks also informed us that he wished to plead not guilty. I placed an ankle monitor on both, escorted them to the ground floor of the station, and released them both. What a mess. So we are here discussing in this judges panel what abilities a trooper has when they are in an off-duty capacity. Good. No one has responded to my cry for food. So the way that this was ruled was Judge Hauser had dismissed the charges with prejudice. The prosecution requested a stay of judgment and for a judicial panel review, because in the ruling it stated that no matter if the trooper, the reason that the charges were being dismissed is because the trooper was the trooper was off duty, but at the same time he was in uniform. So it is he was in his uniform, but he wasn't clocked on duty, so that's why the charges were dismissed. So that is where we're at. That is what we are here to get settled.
Yeah, what's up? Hold on.
Hello. So that is where we're at. Jake's about to crash out, so I am on the hunt for some food.
Hello, Your Honor.
Hello.
How are you doing this evening?
I'm doing just fine, trying to track down somebody to open up a food joint so I can get some food.
Yeah, I got some food for you. Here you go.
Oh, why, thank you.
You like cake pops?
Yeah, that works.
There you go.
Thank you so much. That should hold me over. Now I get drink three food. Well, I'm about to have drink two food after I consume what I had.
If you need more, let me know.
All right, will do. Thank you.
Of course.
There we go. So we just big chilling until this gets going.
Daddy.
What are you doing, crazy?
Oh. He. Oh. He. Whoa, he. Oh.
So, are we looking at just your ruling, or are we looking at the case as a whole? I've not been clear on that yet.
For the moment, it'll be just my ruling.
Okay.
Give me a second. I'm gonna go change up there back.
Yeah. I'm gonna reread his ruling then, just to make sure.
All right, so the ruling that's in question here. At this time, a review has been completed and a complex determination has been made. The arrest on Tim Banks is to be voided and dismissed with prejudice. This is based around the fact the officers in question were not on duty at the time of the arrest. While the court is not raising the question of whether or not an off-duty can conduct an arrest, the court's issue arises from an off-duty officer being in full uniform while actively off-duty in what this court views as him misrepresenting himself and as on duty. This view is also enforced from the uniformed individual attempting to clock on duty multiple times as seen by his phone, which is on the body cam. It is the manner of the arrest that draws concern towards its legality. To that end, the court is moving with a dismissal with prejudice. Okay. Hi, Alex. Oh. You know, I can't complain. We're getting ready to have this judicial panel for my favorite case I've been working on for the last couple of weeks that has been driving me up a wall. State versus Banks. And because I'm the seated judge on it, I'm automatically on the panel. Yay, yeah. Bradley threw a fit when Jay made his ruling. And now Bradley has stepped in on the case because of Jay's ruling. Nice cold lemon water. Water! Yeah, so what got us to this position is Bradley Ado, who is the head of the prosecution's office for SAST. He stated, Your Honor, the state respectfully objects to the court's ruling voiding the arrest and dismissing the matter with prejudice on the basis of the officer's duty status. The court expressly states that it is not raising the question of whether or not an off-duty officer can conduct an arrest, yet the ruling simultaneously voids the arrest based upon the fact that one or more more involved officers were allegedly off-duty at the time of the incident. Respectfully, these findings appear internally inconsistent. If off-duty officers are not categorically prohibited from acting in law enforcement capacity during active emergencies, then duty clock status alone cannot independently invalidate otherwise lawful police conduct absent some clearly established statutory and constitutional prohibition. The implications of the court's ruling appear to extend far beyond the current case. Under court's reasoning, an officer not formally clocked on duty or not outwardly operating in a traditional patrol capacity effectively loses recognized law enforcement authority despite remaining a sworn police officer. By extension, the same logic could suggest that individuals appearing before the court without identifiable uniform of the legal profession would likewise lack recognized authority to practice law and make legal arguments or handle cases despite being duty licensed attorneys. The state submits that the official authority derives from law enforcement appointment, certification, and status, not merely outward appearances or attire. Such a framework will create significant uncertainty not only regarding off-duty response situations, but also undercover
Are there any lawyers
operations.
out there for this one?
But
I
understand.
believe so, yes.
Yeah. James Jones won't be here, from what I understand.
That I do know.
But I believe Harrelson is the other attorney. I think it's Harrelson.
Yes. It would be Jeff Harrelson.
Yeah, I would think, will be here. And then whoever the state is sending, which I assume will probably be Ado.
I would be surprised if it wasn't Ado.
Speaking of that, is he trying to like work around whatever the outcome of this panel is going to be?
Don't worry about that for right now. There's another hashing out going on that I'm slowly losing my fucking mind over.
I feel that. Okay. So we're just here based on your.
Yeah.
So your stance in just the layman's terms is that the officer was not on duty at the time.
My stance is that he wasn't acting in good faith as an officer because he was fully uniformed but not actually on duty.
And then the state's objection is that he gets his authority from a lawful appointment certificate status. And essentially that
Being a sworn peace officer and acting in response to a crime in an off-duty capacity.
Gotcha. This case,
It's been a mess.
It has appeared to be a very big. I guess there's 4 people involved. 2 of them were troopers. One was uniformed and off duty. The other one was ununiformed and off duty. And then there's the defendant, who is obviously, we know what he's being charged with. And then there's the other guy who I guess was beating up the ununiformed off-duty trooper.
Correct.
So I'm still confused how the defendant is even, how he even went about getting charged. I guess he left at one point and then come back with a knife?
Yes.
Okay.
He was from the start to end. He was part of this incident the entire time. He walked in first, and then the assaulter came in behind him and assaulted the civvy, the officer that was in civvies off duty, and the trooper in uniform was standing in the corner and watched it go down. Drew a weapon, aimed it at him, and the defendant in this case was there, kept making approaches towards them while he was trying to assert his authority on the scene and get it under control. He kept telling him to back up. He kept walking in, backing away, walking in, backing away. Finally, he walked out and left, but then came back with a knife. And then ended up dropping the knife, but then still kept approaching, so he got taken into custody.
Okay.
And was, if I recall, was charged with obstruction.
Obstructing government employee possession of controlled substance. Then did you rule
Controlled
that
substance
brandishing amendment
and
was-
brandishing was approved.
It was approved. Okay. Yeah. That, something fishy about that. I mean, do we know, like, would the state even be able to prove that there was an intent on Mr. Banks obstructing the situation? I mean, like, did the two individuals know? Did Mr. Banks know the other guy who was beating up the ununiformed trooper?
It was also Banks. It was
Banks was-
Timothy Banks. This one's Tim Banks. The other one's Timothy.
Oh, yeah, because that's not confusing. So I guess they did know each other? Like, I'm just trying to...
I'm not
figure out.
entirely sure on what their relation is to each other. I mean, one could assume that there's some type of family relation there because of the names, but at the end of the day, that hadn't been clearly identified to the courts yet of what their relationship is to one another. Or there's a lot of questions I had for this, and I was trying to get this before me so I could hear everything in person, and we snowballed into this.
Snowball really fast into this.
Yes, it did.
Somebody knocking on this door.
Yeah, I think so. Maybe not. Yep, someone's knocking on this door.
Do they have keys?
Enter. Or maybe not. Okay.
Yes, he changed his mind.
Oh, never mind.
I apologize.
Yes.
Sorry, Mr. Bradley Ado is here, Mr. Hauser.
Hell, buddy, you should play the fucking lottery on that.
Is Mr. Harrelson out there as well?
Negative. Just Mr. Ado.
I could have sworn I saw Harrelson earlier.
I know Reddington was here. We told him to leave since he was not involved.
Oh, maybe it wasn't Harrelson.
What would you like me to say to Mr. Ado, or...
I would just sooner have him have a seat out there, and any questions can be asked.
Mr. Harrelson said that there's some delays with this flight. He should be here in 15 minutes.
Alright, I'm gonna let Mr. Ado know that you guys will talk to him in a bit, right? right.
All right, let's put a pin in this conversation here until we can have it in front of both councils, so they can. So if they have questions, comments, concerns, or wish to speak on their side, they can. Is that agreed?
Agreed.
Sounds good to me.
Okay.
If you want to let Mr. Ado know that Mr. Harrelson will be here in roughly about 15 minutes.
I'll go out there and let them know now.
All right, thank you.
Problem.
Can we not? Why is it not letting me drink my coffee?
Is your coffee expired?
No, I just got it out of the machine out there. What in the world?
There you go. I'll put. Grab that out of that bag.
Oh. What a lifesaver. Appreciate that.
Mm-hmm. Don't want to be looking at my thighs. There we go. Yeah, not the coffee.
What was that, what was that situation with, oh, is he Lieutenant Steel Castle?
It was a lot of confusion.
That was just a whole lot of hubbub.
But it seems like you all just can't escape it.
Welcome to the Department of Justice. Well, Mr. Harrelson's stuck in the office corridor.
Do they not have keys to that? I think he's gonna come back for his pistol.
Well then, Well, he didn't stay strapped, so I guess he'll get clapped now.
I guess so.
The case that I was overseeing you on. I got the document issued. There's current IT issues here at the courthouse, so I haven't been able to do the refund to them yet.
Gotcha.
So once the IT issues are resolved, I can finish out the refund. But I've gone ahead and provided them the required documentation for the release of their vehicle.
So they did pay the fines then to the state police upon the arrest.
Yes, they were fined and jailed upon the arrest. So once the IT issues resolved, we can we can get that. I'll walk you through how to do the refund.
Gotcha. Hauser, do you want your pistol?
It's not actually there.
No, it's a prop. I knew you were bringing water guns to the office. Just because it's summertime doesn't mean you can go spraying us with water guns. Hey, that's a bucket handle, little SIT. It's not a bracelet. It's a handle. Here. You may enter.
Beautiful. Beautiful, beautiful.
I'll let him know that you guys will be out soon.
All right, we're about to get this road on the show.
Did I see a new case from Axel Foley again?
Yes, probably so. Yes.
No surprise. Yeah, he's filing for an expungement.
Nope. There's another. He has another criminal. Yep. It's 87. No, not 87. 86.
Well, yeah, there it is. What would you know? That guy can't stay out of trouble for nothing.
Just waiting. Sitting and waiting and waiting and sitting. Why are you so loud, little? Why are you so loud, little SIT? Goodness. Had a big yawn there. My hair is a mess.
Are we waiting on something?
No, I'm not shaving off my hair, but I do need a haircut. I believe we're just waiting on Judge Hauser to finish his long process of thinking. I usually like.
No, I don't know what the hell we're waiting on.
Oh, well, okay, there we are. There's the answer.
That's just a very long moment of silence. It made me feel a little awkward.
I usually shave the sides, like completely shave the sides, and then I'll take like an inch off the top. All right, I think all parties are in the parlor, so if we're ready to do this thing.
Okie dokie. Let me take the big chair. It's your case.
It's your rolling.
Ugh.
Very valid.
And for all parties here, remember to use the court mics that are placed in front of you. You have to reach forward and tap them on.
Wait, we're
Since
getting
these
this
panels
road on the
are
show.
fairly informal with how the structure and flow goes. So for these ones, so for this one, it's going to be a 3-judge panel reviewing a decision made by the Chief Justice is in regards to CR 1076 State v. Banks. We can start with statements from either counsel as if they wish to speak, or we can start with a judge's opinion.
Hi, Jeffrey Harrelson, Your Honors, and if it's all the same to you, if state's okay with it, I'd like to hear the standing opinion from the judge, and we can kind of set into context what this discussion will be about.
I do have an opening statement, Your Honor. If you wish to hear it, others we can move forward with hearing the judge's opinion, and we can argue from there.
Oh,
You may.
Well, sure. And go ahead.
Sorry, Harrelson, were you going to say something?
No, no, of course not. Well, we'll all do the same thing. I'll let him go first, though.
Okay.
All right, here we go. Here comes Bradley Ado. Pop.
May it please the panel. So this matter is simply not about the court, whether the court
character
agrees
looks
or
different.
disagrees with the conduct of the involved officers. The issue before this panel is whether the Chief Justice, during a supervisory review, created and applied a new constitutional limitation unsupported by statute, unsupported by departmental policy, and inconsistent with the realities of modern law enforcement. The supervisory review expressly stated that it was, quote, not raising the question, end quote, whether off-duty officers may conduct arrests. Yet, despite that statement, the ruling proceeded to void an arrest entirely and dismiss the matter with prejudice solely because one assisting trooper was allegedly not administratively clocked in during the time of the encounter. Respectfully, the state submits that this reasoning is internally inconsistent and creates a subtangible legal and impractical consequence far beyond this case alone. The state of San Andreas off-duty policy expressly authorizes off-duty officers to exercise police authority, conduct arrests, direct individuals, and intervene during emergencies. The policy regulates such conduct administratively. It does not distinguish between sworn authority based on payroll status or whether a clock-in process was completed. Most importantly, the ruling failed to address the independent actions of the defendant himself, including repeated refusals to disengage from an active detention scene and returning towards officers with an armed knife. Those actions independently establish probable cause and the officer's safety concerns regardless of any administrative duty status dispute. The state is not asking this panel to approve improper conduct or ignore policy concerns. If internal policy violations occurred, those matters may be addressed administratively by the department. But internal policy concerns are not the same as constitutional violations requiring dismissal with prejudice. Respectfully, the issue before this panel is whether a sworn peace officer ceases to possess lawful authority during emergencies or non-emergencies merely because they are formally not clocked in, and whether such administrative status alone invalidates otherwise lawful police action. By that same logic, a judge is no longer a judicial officer capable of issuing rulings simply because they are not presently in robes or formally clocked into active. They're not formally clocked in at that exact moment. Respectfully, the authority derives from lawful appointment and sworn office, not solely from outward appearance, attire, or administrative payroll status. The state respectfully submits that the answer must be no, and respectfully requests that the matter be remanded to allow the prosecution to move forward on the merits of the underlying conduct rather than be barred solely by an administrative duties status determination. Thank you.
Mr. Harrelson, if you have a statement to share.
Yes, with pleasure, Your Honor. I'd like to start
Remember to
stating-
tap the button on the court mic in front of you.
Might have to do it twice. Can you all hear me well?
Yep.
All right. Well, thank you for hearing what I got to say. With respect to the state's argument here, I do agree with part of it. This case is about something different than what it initially seems. What I want to state is that this case is not necessarily about whether off-duty officers can ever act under the color of law. Rather, it's a fairly narrow argument that was made in the court's original ruling. The case is about an off-duty officer who, in this particular situation, was in full law enforcement uniform, presented himself as active law enforcement, but also during the incident, after the beginning of events unfolding, attempted to clock in as a law enforcement officer. I'd argue this creates a constitutional reliability issue regarding the legitimacy of this particular arrest itself, rather than a mismatch between constitutional law and department policy. Going back to the original ruling, it was fairly narrow in scope and doesn't apply to all broad arrests in the future or in the past. Now, I do remember the court didn't hold that off-duty officers have zero authority or that intervention was illegal when off-duty. Specifically, the ruling focused on the manner of this particular arrest. There was an appearance of the authority of active duty, and then the fact that evidence showed an officer attempting to clock in during the actual encounter. Therefore, this was an issue of police legitimacy, not merely an issue of administrative employment status. Now, you've heard the state say that officers retained their authority while off duty. I don't disagree with that. The issue is not authority. The issue is a constitutional reliability, that there needs to be an identifiable method of lawfully executing authority as a police officer. Another way of saying that is that a badge does not cure the structurally defective state action in this case, and citizens need to know they're dealing with clearly established lawful authority, not just somebody wearing a tan shirt and a tie. Of course, there is off-duty policy for the San Andreas State Troopers. I'd like to remind the court, as they know, internal department policy is administrative. By its nature, it does not and cannot override constitutional scrutiny. Just because policy allows it, or because a constitutional precedent or ruling, quote, overrides internal department policy, end quote, that doesn't make the detention, in this case, constitutional. Of course, policy can allow intervention that is more restrictive or equally restrictive to the Constitution, but I would say policy does not automatically authorize the appearance of being on duty while you are not. It doesn't allow blurred operational authority under obscure or mysterious guidelines. It also doesn't really allow an unclear sort of custodial legitimacy where, you can make this detention while acting as law enforcement, but not presently being active as law enforcement. Just a reminder that administrative policy is not the Constitution; they're separate. I'd end by saying, the attempt to clock in, while the state has argued that it is a minor element of this case, it matters. There's an inherent uncertainty from civilians regarding whether this person has operational authority. But beyond that, the officer himself was uncertain about his role. He appeared to recognize that uncertainty by realizing that he was off duty and attempting to correct that fact. And that's what evidence shows, not merely a conclusion drawn by the defense. That supports ambiguity and the concerns of legitimacy that we brought to you today. Ultimately, the remedy here was to dismiss the case with prejudice. The court obviously has authority and has exercised that authority in the past to impose fairly unusual or extraordinary remedies where governmental action itself was unusual or extraordinary. There was no missing discovery or evidentiary issues. This wasn't just a procedural harmless error. I mean, this, as we've said, is a reflection of the integrity of the arrest itself. In summary, the defense is not asking this panel to hold that off-duty officers can never intervene in incidents. We only ask that when the state exercises coercive authority over a citizen, that authority needs to be exercised within clear, identifiable, and constitutionally reliable boundaries. The original dismissal of this case recognized and respected those boundaries, and that they were blurred here, and that determination that those lines were blurred was structurally sound. Thank you.
Judge Brown, Judge Bliss, do either of you have comments that you'd like to add to the record?
I do have a couple questions for Mr. Harrelson, if that is permitted.
Of course.
Mr. Harrelson, at what point, to my understanding, there was a uniformed officer, though his duty status, he was not clocked on administratively. At what point did this situation become constitutionally blurred? And then at what point did it unblur itself?
Yes, Your Honor, thanks for the question. The issue in itself was that the interaction was constitutionally blurred.
Void
from the
headaches,
start.
nausea,
Okay.
hell hydrate. Hell
The act
hydrate.
of the trooper changing his role or clocking in midway through the encounter was merely evidence of the fact that it was constitutionally blurred or uncertain. And at what point did it stop being blurred? Well, I'd go so far as to say we've never fully resolved that constitutional defect, as the client is still required to appear in court today.
So let me ask you this. Where does a peace officer derive his authority from? Is it his administrative duty status, or is it his sworn position?
Sure. Obviously, the law, I mean, the easiest answer to that is that the law grants a peace officer his authority. So the position within that sort of governing body that grants him that lawful authority or that employs him, necessarily that doesn't give him the authority. It is the law. The problem is that...
Well, no, I mean, without getting too overly complicated, the question was, does he get his authority from being administratively clocked in as to draw a paycheck, or is it from his commission in him taking an oath of office? It's one or the other.
Right, of course, it would be his oath in office. Yes, it would not be administratively his position that grants him that lawful authority.
Got you. So
the issue is also it's a separate issue that citizens have to be able to trust someone appearing
Yep,
in uniform
I agree.
is actually acting within clearly established
Well,
authority.
Okay, I guess, but so it's fair to say that I don't know who the uniformed individual is sitting next to Mr. Ado, but he is a peace officer by his appointment and his oath. Whether he's in that uniform or not, he is still a peace officer within the state of San Andreas, right?
Yes, Your Honor, and I'd
Okay.
assume by the fact that he stands before us that he's clocked in and that he's in uniform.
Well, regardless, his label as a peace officer comes from his appointment and his oath. Just like mine, I am a judge. I mean, I guess one would argue that my uniform would be a robe.
Brown is
but
making
it's not
valid points
statutorily
here.
Required that I wear a robe when I'm performing my duties. But I mean, there's many times that we as judges
Yeah.
perform. certain
Yep, you're
aspects
watching
of
this
our
go down.
job outside
Brown
of
is
an official setting.
wow.
or
Brown is surprising
outside
me.
outside of our robes, outside of the courthouse, like signing warrants electronically. Would us doing that be constitutionally blurred by your arguments?
Your Honor, I think as I've stated, to extend the ruling of this court to situations outside the one particularly in question would
Well, I mean,
likely
if we're
be
going to
an
set a
extension of
standard,
this.
if we're going to set a standard in this case, it should just apply throughout, right? I mean,
Well, yes, and again, Your Honor,
Yeah, he
the
is.
case here is not about whether off-duty officers ever have police authority or don't have police authority. That's fairly clearly established. The case is about, in this case, when an off-duty officer in uniform presented himself as law enforcement without having, I guess, the permission to do those actions as per his
We have a T-Rex.
own employment status or being clocked in. It
Erica
creates an issue
Gaming
of
Zone coming in with that follow.
we're
Welcome to
going
the Terror
back
Squad
to this
family.
argument that because he was not actively clocked in, he is not within his rights to act as a peace officer.
Well, Your Honor, I would try to clarify that this is a totality
Hello.
of the circumstances argument, that it applies to the ruling which was narrowly made within the scope of this particular interaction and should not be generalized to all professions or all sworn authorities.
But yet it
I don't
is.
currently have any more questions for Mr. Harrelson.
Thank you, Your Honor.
Let me turn on my mic here. Hello, is this on?
Yes, Your Honor.
Okay. Mr. Harrelson, I don't have any questions, but I will put it on the official docket record for this panel. When I was reviewing all the paperwork for this court case and this docket, when it came to this particular situation in question that we find ourselves before now, I looked into case laws that are present through the Supreme Court and found a consistency in Monroe versus Papp and Screws versus the United States, where the Supreme Court has repeatedly recognized that no matter what their duty status is, if they are wearing a uniform or have a
Void
identifying
headaches,
badge,
nausea, hell hydrate.
they fall within their rights to act on any crimes that they witness. They have the power to exercise their authority that is driven from their status as a sworn peace officer. And that is why I made the decisions that I did on this case. It's not that I was simply coming up with things on the fly. I spent some time and did some research and looked at what the Supreme Court justices of the land were saying when it came to a matter that is as finicky and very precise as this, to see if they had any situations that they had already ruled on to provide guidance for me trying to decide what to do in this situation. And outside of that, I have nothing further. I got your hell hydrate. Thank you.
Counselor, I don't have any questions for you. I know we have Judge Montepelico here. I am not aware if she has reviewed this case. Is, is that all? But if the panel has no further questions for you, you may be seated.
Sure, thank you.
Do either of you have questions for Counselor Ada?
Yep, you messed me up a little bit.
I do.
I was in the middle of giving my spiel on why I ruled, and you hit me with that hell hydrate, and I was like, let me finish this monologue.
So, is it your position, just so I can get it correct in the most basic terms possible, is that at least the one uniformed officer was acting within his authority to handle the situation that he did?
Your Honor, it's our position that regardless of administrative timekeeping, that if an individual is in uniform, they have been sworn as a duly appointed police officer, that they have the authority to take police actions as.
And that has been my stance throughout this entire case.
So, what about individuals outside of uniform? They're still peace officers, nonetheless.
Correct, Your Honor, and that's where the contention comes in from the state, is that even if there's an officer who is not in uniform, they are still considered a peace officer, and have the authority invested in them by the state to conduct police actions. I may use an example of EMS personnel, Your Honor, where let's say just because an EMS personnel, a member of EMS medic, is not currently in uniform and is not administratively clocked in, does that mean they do not have a duty to render aid to someone who is dying on the ground? Or are they to then just sit there and watch them die on the ground while their counterparts who are clocked in and are in proper uniform respond? Or should they, actually try to take care of the situation until their counterparts with proper equipment and services can provide a further additional higher level of care? That's the standard that the defense is asking you to apply here, is that if they're not in uniform, they're not clocked in, therefore their authority does not exist, or their authority is limited in scope even further, and the state disagrees with that.
So in this case, at least to my understanding, an individual come in and begin punching a third individual who I believe was a ununiformed off-duty trooper, correct? So
ran out of drink. I gotta grab some more.
In the matter before us pertaining to this case, he did not strike anybody that we're aware of. His is just merely an obstruction charge.
The defendant in question?
Yeah.
That I'll have to defer to my co-counsel, Your Honor, as I'm not prosecuting the case. I have stepped in as chief counsel because of the standard that is being set, the precedence being set that I'm challenging. To my understanding, an individual walked in, punched another individual, a uniformed officer who, by the defense's argument, was off duty but in full uniform, pulled out their appropriate service weapon to attempt to prevent them from escalating even further.
Oh, he lied. He said in his report it was a civilian pistol.
To then also pull out their weapon to handle the situation. That is my understanding of the case, but I'm not the prosecuting attorney on that.
Void headaches, nausea.
Oh, dude.
Hell hydrate.
You waited until I got my drink.
I just just wanted to see if there was. You answered what I was looking for that matter. So what is the state police policy? Again, of course, this is not statute at all. This is administrative policy. But what is their policy pertaining to off-duty performance?
Oh, y'all are just coming in with everything. I see that stretch.
No, I got it.
I'm a hugger. Who the hell am I going to hug on the stand, Aries?
You're talking about the interventions section, Your Honor, correct?
I'm trying.
The whole policy is about a page and a half. I don't know if you want me to read the whole thing.
No. I'm just trying to.
There's a section in regards to off-duty interventions.
Sure, that'll pertain to this matter.
Okay. So the policy states, when off-duty officers should use their discretion in exercising police authority to make an arrest or direct the actions of another person's, considerations including the availability of qualified assistance or communications to summon assistance, cell phones, radio, etc., access to critical equipment, and the threat to public safety if intervention does not occur, whether the officer is armed, person of interest who may interfere, resist, or assault the officer, and the serious or minor nature of the incident of the crime. 1. If there is a reasonable and viable alternative, officers should refrain from taking enforcement action when out of uniform and/or off duty, calling 911 to summon uniformed officers and serving as good witnesses rather than intervening, unless someone's life or personal safety.
I got it. I got it. I know how I'm going to do it.
Appropriate. 2. If law enforcement powers are utilized in an off-duty encounter, off-duty officers will be required to submit the appropriate.
I'm gonna do it. I'm gonna do it.
Possible, but no later than 24 hours following the incident.
Okay. I've got no further questions for him.
Judge Bliss.
Mr. Ado, so the question I have in regards to the situation does a uniformed officer, even though they're off duty, still hold the power and authority to give orders to off-duty officers that do not have any identification on their persons to act in a law enforcement capacity?
Your Honor, I believe anyone has the authority to ask or request for assistance, no matter whether or not they're a police officer or not. Police officers have frequently received or requested assistance from general public, whether they're not, and those who are not even law enforcement officers. So to answer your question, Your Honor, I would say yes, he can direct and summons additional assistance, as I mentioned in the intervention policy. I would say whether they were acting appropriately.
I have no further.
Counsel Radio, I don't have any questions for you.
Thank you, Your Honor.
Harrelson was abducted into the rafters of the courtroom.
Judge Brown, do you have any final opinions on this matter?
None to put on the record.
Judge Bliss?
I have no further comments than what has already been discussed and that I've made thus far in this panel.
Based on both of their statements and the questions provided, plus your own review of the docket, what do you believe is the proper course of action to move forward with?
I was preparing to see this before me in trial, because yes, there are some questions that need answers that took place during that scene, and that would help alleviate a lot of the issues that had arisen from both state and defense during this. So I was seeing this go to trial to address those questions and at this point in the stage settle it in court.
On the particular matter of my decision to dismiss, what do you think? What is your view?
I feel, based on Supreme Court precedents, the issue which you saw fit to dismiss the case was not properly founded, based off of how the Supreme Court has ruled in situations that pertain to matters like this. They've always found that even if they are not officially clocked on duty, and if they are in uniform, not in uniform, as long as there is some way that they identify as a sworn peace officer, they are within their powers as a sworn peace officer of the law to intervene in any criminal actions that they see fit. So I feel that your decision should be reversed, Your Honor.
Judge Brown?
Based on the conversations that we had here today,
Void headaches, nausea, hell hydrate.
Hell hydrate.
That the decision that you had wrote, while I could see it being enforced in another situation where the facts align, with the presence of at least one uniformed officer.
Yeah, thank you.
He was acting within his authority given to him by his appointment and by his oath. I believe
I'm very impressed with Judge Brown.
The decision should be reversed and that this should proceed to trial.
Based on the decision by the panel, I'm going to overturn my previous decision, and this will move.
We're going to trial.
Is at the next available convenience. That will conclude this panel, and is any subsequent proceedings will be handled by the seated judge of Judge Bliss.
Counselors, I will be in contact with you here in about an hour or so to work out date availabilities for all parties. Hey, could you turn on your mic, please?
Yes, that would be helpful. If I might briefly address the court. Your Honor, while I appreciate that we were moving forward to trial and we were ready for such a trial, I would request that the court honor our request to keep a panel of 3 judges based on the numerous amounts of concerns regarding constitutionality and various rulings and overturned rulings and rulings in question, and I would cite the fact as well that Judge Bliss herself, Your Honor, you did hold me in contempt over questioning some of those rulings. I would request that the panel of 3 judges be present to preside over the trial as opposed to the single one.
Your Honor, I have No objections to making this a 3-judge panel for the trial itself.
Understood. The 3-judge panel will be seated by yourself, Judge Brown, and Judge Montepelago.
Thank you, Your Honors.
If nothing further, we can close this panel out and move forward with a trial scheduling.
Your Honor, just a question.
Yes?
Can the because I wasn't here for the initial request for the 3-panel judge. Was there, other than the contempt charges and the overturn, return, was there something else missing that I missed as a reason why a 3-panel was requested? From my review of the docket, it seems the majority of the arguments is the state has not been involved in the majority of those arguments.
Counsel, are you objecting to my motion, or what's?
No, I'm asking for what the additional. Well, I guess we were meant to address the court, not each other. Your Honor, I'm asking for an understanding of the additional, as I mentioned in my initial brief. I was looking for any newly discovered evidence, intervening change of controlling law, extrajudicial bias, personal conflict of interest, or an actual procedural deprivation preventing the defendant from presenting arguments before the court. Like, was any of this brought up during the initial request? Just so we have it on the record.
Do not.
Judge Bliss, I believe that question is better directed towards yourself.
Allow me to review this real quick.
I do believe this was potentially, and defense can correct me if I'm incorrect, but I believe this was done in a motion in chambers, potentially.
To be honest, if it was, I do not recall. I've had 2 meetings with counselors in chambers, and I believe the head for prosecution was present for both of those meetings. So if it was mentioned, I do apologize that I do not recall that request. But I will say that I'm going to allow it on the fact that the defense is correct in the fact that I have held him and his second chair in contempt in this court already, and the fact that there's been continuous arguments over my rulings and the reversal of this ruling that we're seated for today, just to safeguard the laws and the court's job to find the appropriate and do justice in accordance with the laws, is the reason I'm going to allow for a 3-judge panel for the trial itself, just to safeguard and to protect us from ending up in another situation that we find ourselves in tonight.
I understand, Your Honor. I'm not against the 3-panel. I don't believe the primary prosecutor is against the 3-panel either. But my question is more, as they filed for a supervisory review, usually there needs to be some type of newly discovered evidence or some type of event that occurred other than a disagreement with Your Honor, or it, like some type of procedural conflict or procedural error. That's what I'm trying to understand, Your Honor.
It has been mentioned that I've been showing bias in this court case, and to protect these claims of being biased towards one side versus the other, I'm going to have additional judges, and I plan to, once we had an official trial set in stone, and I spoke with my fellow judges about it, I was also going to bring this up to both counsels on the docket before we ended up having the situation that we are currently in, about having a three judge panel for this case, just because of how messy and argumentative and all the issues that have arose since the beginning of this case.
Actually, Your Honor, just one final point of order. Can we get clarification on Rule 19, since that appears to be a hot topic item in this case? I've heard from my prosecutor. My understanding is that there's been one argument that's been used 3 different times in 2 different ways. We can just get clarification on that, just to ensure we're all following the proper rules of the court. Just understand that once an argument has been made, we're allowed 1 appeal to attempt to reverse that, and then once the final judgment has been made, the final judgment's been made, and move on for trial.
So in accordance with Rule 19, when a motion is filed, the opposing counsel is allowed a response. The judge makes their ruling, and then after my ruling is made, either side may submit 1 additional written or oral argument. No more, no less. And then from there, I'll review the arguments and then make the decision of either to uphold or overturn the ruling. Once that has been done, there's no more on that topic. That ruling is final.
I appreciate it, Your Honor. I believe my co-counsel has 1 point of order as well. He's the primary prosecutor on the case.
Yeah, Ms. Bliss, this is mainly a question for yourself. I know that we put in the docket that there was a amendment of charges, but we never got a ruling on it. If you could clarify.
I thought I'd ruled on that. I guess I got caught up with all the other motions on the docket.
Your Honor, sorry, Your Honor Hauser, I believe this may be relevant to a conversation we were having in another case. You can help weigh in on this as well.
What is the question being asked?
Amendment of charges. There's a pending motion to amend the charges.
The motion to amend was requested once when discovery had began.
State reserves the right to amend charges. To amend charges and formally charge a person with said charges.
Yes, sir, but this happened after discovery already began. So, do we need to have another probable cause hearing for this charge then?
Are you amending the charges or formally charging a person? I need you to be specific, as the wording will change the answer.
Well, Your Honor, if I may.
Mm-hmm.
I believe that the state intended to introduce an additional charge under a separate title for the possession of a weapon, but that was after the probable cause charge the probable cause was ruled upon. So it's an amendment, but it's not of an included offense. It's a more of an introduction of a charge. With a
That would be
element.
worded as a formally charging, in my personal opinion, as to where if you are formally charging a person is with a additional charge during the discovery phase, I would say no PC would need to be found. However, that'll be a thing the judicial board will need to sit down and discuss about how to move forward with that.
So with that, the request to amend the charges and introduce the new charge is approved, and it doesn't require a PC. It will be argued at trial.
So just for my clarification, what's the limitation on that? If state wanted to charge my client with murder for this case, just because it's a new charge, could they do that, or would they need to meet some standard of probable cause to introduce that additional charge? Where do we draw the line?
That is what we'll need to sit down and hash out is at a later date. However, they would still need to approve that.
Right, I understand the reasonable doubt discussion, but if this is being decided at a later date, then could we have a stay on the addition of a charge for possession of a weapon?
No.
Is it okay?
The charge that is being brought forth is 9/11 brandishing a deadly weapon.
I mean, if
we will stipulate is that when they wish to add a charge, it does on that degree, it would need to be directly associated with the docket, so they couldn't charge just whatever they wished, and they would still need to get it approved is as a motion.
I mean, to kind of put this to rest, Your Honor, I mean, defense counsel's here, the prosecutor's here, all three of Your Honors are here. We could have a formal impromptu PC hearing in regards to this additional charge right now, and that would that I don't know if the defense.
The defense has no objection to that. We can hash it out if the court is willing.
I mean, I'm here for it. I ain't got nothing else going on.
Judge Bliss, that is your determination?
If both counselors want to argue this out, by all means, we can hash this out right now.
Judge Bliss, go ahead and take your seat. Montepello, go get up. Go sit down over there.
If we can just have a few minutes, Your Honor, to I think we all can use a small
Yep.
break. And,
everyone
for this.
Everyone take, we'll call it 5 minutes. Be back here at the top of 5 minutes. So it'd be 9:20 Central for me.
I need a drink of water after all that.
All right. Let me think about it. Yeah, I have an answer.
Would you like this to remain closed or unlock the doors?
You can unlock doors. Since it's a PC hearing, you can unlock the doors now that the judicial panel's over.
Okay.
All right, thank you. All right, gotta think about something for a second. All right, I gotta use the restroom. Yes, this is cinema. This is great. I had to step away, use the restroom. So now we're having an impromptu PC hearing for their motion to add charge 9/11 brandishing a deadly weapon. Yeah, this is definitely a topic we need to discuss and figure out because.
Well, I don't know the weight of my opinion on this, but they do reserve the right to add and change, or to add and take away charges and stuff. But that is an executive authority. It still should fall under the checks and balances of our judicial review.
So when they submitted the motion to amend during discovery, this motion to amend came after they discovered the body-worn camera footage of the situation, which is on the docket. And now the question I have for this is, if we're doing a PC, usually our PCs are based on solely on the arrest report. But if a PC to add a charge during discovery is done, do we also do we use everything that's also already been discovered, or do we solely rely on the arrest report itself?
So, this is where it gets really iffy for me. I come from a background to where when you do your initial PC/arraignment, or whatever you want to call it, I've only traditionally ever went off of what the report says. Because if you can't establish PC through the report alone, you probably don't have a good case to begin with. But because new evidence, quote unquote, was discovered, I think and they're trying to amend it post initial PC, you could probably use that.
Yeah, and that is the situation at hand, because they wanted to. A while back, I had set a precedent that if they want to amend charges prior to PC, then the arrest report and everything associated in the initial arrest report used for PC had to support the facts of either the change of the charge or the adding of a charge. Outside of that, they are free to drop as many charges as they want. But if they wanted to change out a charge for another one or add a charge, I stated that it's required that the evidence and the facts in the arrest report that's going to be used to determine PC has to support the change of that charge. But now that this is an amendment during discovery pretrial phase, and it's after the admittance of a piece of evidence to support it, the question comes into play for all of our sakes is, are we going to be allowed to use the evidence that was used to request the amendment of the charge?
That's a good administrative question, Judge Hauser.
Gonna keep it a buck. Haven't been paying attention. You're back.
Well, I think this will be a good discussion that we can have with Ares when we come back to deliberate on it.
Yeah.
Oh, they're not ready yet. We're still missing Ado and or we're missing prosecution and Judge Ares.
Sounds good to me. Well, I guess we'll sneak back here. No, see, so like, whenever I go about, like when I do my initial PC hearing, I go off the report alone, not officer testimony, not body camera.
When I do the initial PC hearing, whatever they have submitted that is part of the incident report. So if they have body cam on the incident report when they file the PC hearing, then it's fair game for PC hearing. But if it's not attached to the initial incident arrest report that's filed with the charges, then whatever the facts say in that incident arrest report that they filed with the charges is what I go off of.
And not only that, so with brandishing, they've got to prove that either A, they presented the deadly weapon in a rude, angry, or threatening manner, or B, that they made gestures or held the object to simulate a possession of a firearm to instill fear, which a knife is not a firearm. So,
hold on. Let me pull up the penal code for this so I can read it and refresh my memory on it.
Yeah, that's what I was just doing.
Here it is. All right, brandishing a deadly weapon. A person commits brandishing a deadly weapon when they. All right, a person commits brandishing a deadly weapon when they draw or present a deadly weapon in a rude, angry, or threatening manner, make gestures, or hold objects to simulate possession of a firearm to instill fear.
Well, it's very hard to hold a vertical knife in the shape of a firearm, so that one's out the window. Unless he went in there screaming, cussing, and threatening people, I'm going to be a hard pass.
I think, yeah, for this, I was looking at allowing it more on the grounds of A, because the way it presented, it went in the body cam footage. It was falling in the grounds of A.
I've not watched the body camera footage. Did he go in there threatening? Did he go in there screaming, cussing, or did he just walk in holding it?
He ran in. He ran in full sprint.
Sure, but I can run down the street with a knife. That doesn't make it illegal.
So in the body, yes.
I apologize. Just so you're aware, all parties are here.
All right, wonderful. In the body cam, he came in while the trooper was in the process of detaining him and moving him to a patrol car. The defendant came around the corner after he was already ordered multiple times to back up or leave the scene. Came sprinting around the corner with the knife while the officer was trying to place the arrested subject that assaulted the off-duty officer in the back of a car, brandishing the knife.
Yeah, I mean,
it's a very.
Yeah, I'm gonna be a hard pass on it.
It could go either or. I would let's go out here and let them do their thing, argue it, and then you can watch the body cam footage when we come back to deliberate.
Yeah, we'll do that.
Just so you can actually watch it start to finish and see what I'm talking about. It was a very messy scene. All right, let's do this thing, girls and guy. Okay, this impromptu PC hearing for CR 1076 State v. Banks is now in session. This is in regards to a motion to amend charges from prosecution to add the charge of 9/11 brandishing a deadly weapon. Prosecution, you will have the floor since you're filing the motion to amend. Once you make your statements, then I'll turn the floor over to defense.
Just checking, is this on?
Yes.
Okay. Your Honor, the defense's argument asks the court to treat this as a simple possession of a knife. Respectfully, that is not what the report describes. The issue is not whether a person may ever possess a knife or whether a switchblade may be legal in some circumstances. The issue is the context and manner in which Mr. Banks displayed it. According to the report, this occurred during an active and escalating scene. Another suspect had just assaulted Mr. Love. Officers were attempted to detain and control involved parties, and Mr. Banks had already been repeatedly told to back away and disengage. Instead, after briefly going around
Someone
the
hit
corner,
the hydrant.
Mr. Banks returned from near his truck with something in his hands. The officer identified it as a knife, ordering him to back up and drop the knife, and Mr. Banks put it away but continued to walk closer. This is more passive possession, advancing toward an active detention scene with a knife in hand after being told to leave and back away creates a reasonable basis to believe that the knife was presented in a threatening or intimidating manner. At probable cause, the state does not need to disprove every possible innocent explanation or prove guilt beyond a reasonable doubt. The court only needs a fair probability based on the totality of the circumstances. For those reasons, the state respectfully submits that probable cause exists for the brandishing of a deadly weapon. Thank you.
Defense, the stand is yours.
Thank you, Your Honor. I'd like to start out by reviewing the statute itself. State wants to allege there's probable cause for brandishing of a deadly weapon. As a reminder, offenses in our penal code require specific intent, right? The person in question must knowingly or intentionally commit the act in question. In this case, brandishing a weapon requires, I assume the state is not alleging subsection B, that the defendant implied the existence of a firearm, and rather that they are charging under subsection A that a subject drew or presented a deadly weapon in a rude, angry, or threatening manner. Based on the evidence that was provided initially, the sworn statement by the officer in his arrest report, he did not allege that the weapon was presented in a rude manner or that the defendant was angry or presented it in an angry way, or that he threatened anyone with a knife. In fact, I was surprised to learn from reading the arrest report that the trooper didn't allege that he threatened anybody with the knife, or even that he made an approach. In the specific language of the arrest report, which I believe has already been entered into evidence during the previous probable cause hearing, the trooper stated, if you allow me to be more accurate.
Go ahead.
Sure. It states, I told him he would be free to go if he entered his vehicle, this being the words of the trooper, the arresting officer, and left the scene, to which he seemed to comply at first. However, shortly after he went around the corner, I heard the door to his truck open and close. I drew my pistol once again, and when I saw him come from around the semi-trailer, I noticed he had something in his hands. I aimed my gun at him and told him to back up and drop the knife or he would be shot. He responded by putting it away and continued to walk closer to me. Your Honor, in this description by the officer himself, he doesn't claim that the defendant approached him with the knife. He merely claims that the defendant became visible after walking around of a semi-trailer. There's no alleged words by the defendant or even non-compliance or threat towards the officer of that knife that would meet that required element of threatening or angry or rude gesture. It really merely says that he had a knife in his possession, or an object that was later assumed to be a knife based upon the search that was conducted upon my client. If all of these arguments fail, there is still the fact that there is a valid defense on its face to this charge, and that would be of entrapment. Entrapment, of course, occurs when a government official coerces or causes a defendant to commit an act that would otherwise be criminal. In this case, let me remind you that a gun was pointed at my client by an individual that was acting in the capacity of an off-duty officer. I'm not rehashing the ruling that was already stated. This is a different situation because this person did not identify himself verbally as a police officer. He aimed a civilian pistol at my client, and this was all in the midst of a chaotic and complex situation in which roles had not been clearly established. The trooper pointed a gun at my client and said something to the effect of, back up or you're going to be shot. My client then backed up. However, there was another individual on the scene that was aiming a gun, and the defendant's own brother, a close family member of his, was on the scene, and his freedom was in question. The defense would posit that a government agent creating this situation of an apparent civilian aiming a gun at the defendant's
So
family
now
member
it has been
would,
brought
with
onto the
any
record
reasonable
that
amount
the subject in
of
custody was the
common
defendant's
sense
brother.
lead to a reasonable reaction of arming oneself with a knife, regardless of whether that knife was presented in a threatening manner, which we know, as according to the statements of the officer himself, it wasn't. Defense rests. Thank you.
Prosecution, do you have any counter?
One moment, Your Honor. My only counter is, as defense clarified, at some point, I believe he was claiming that the off-duty or the individual that was off-duty and in plainclothes pointed a firearm at his family member, at which point did that never take place. The off-duty or in plainclothes officer was using his firearm to hold Mr. Banks at gunpoint towards the wall. The one who was attempting to detain and arrest the brother of Mr. Banks was in uniform. So.
All right.
If you'd allow me a rebuttal, Your Honor.
Go for your rebuttal.
Just one quick point. I know we're all eager to get out of here. Yes, I thank you for pointing that out, prosecutor. I did misspeak. It was actually, in fact, the person not identifiable as a police officer, and who didn't verbally identify, who pointed a firearm directly at the defendant when he then left and allegedly armed himself with a knife. Nothing further.
For clarification for the docket, this is the person that was being detained at the time was Timothy Banks. The defendant on this case was Tim Banks. Do I have that correct?
Correct, Your Honor. The initial detention was of Tommy.
Correct. You're right. Tommy Banks.
Detained.
All right. Judges are going to retire to chambers to discuss. We will be back in 10 minutes.
So I did take a moment to review the body camera footage.
Make sure you're talking in a small voice.
Hello, is there anyone there that could possibly deliver food by chance?
Yes, these walls are paper thin.
Yeah.
Mm-hmm.
So it from the start, he did. Here's where it's very confusing. He did look like he already had pulled the knife out once at the very start of it, and then he put it away and he come inside. And then of course, I'm not gonna go down the route of a self-defense claim. That's not my spot in this. That's up to attorneys to argue. But to be fair, the individual who was not in uniform did just look like a strange ass person with a gun. Now again, I'm not saying that's what caused him to come back with a knife. You know, there's just so much going on. But still, just running, whether it's into a crowded area, whether you may put people in fear, but if that's not your intent behind it, you know, I'm not buying it. I mean, I could go running down the street with a knife just because I feel like it, and if I happen to stumble into a police scene, you know, that's not me doing it criminally. That's just me running down the street with a knife, stumbling into a scene. Now, granted, B, that's not exactly the nature of this, and I understand that. But
Now, the issue at hand, though, is defense has brought it onto the official docket on court record that it was his brother that was being detained. So that is the relationship that we were discussing earlier and trying to figure out.
You know, but he didn't touch on to as why did he come back with it?
Correct.
You know,
Now,
that's
so what my initial intentions were before we found ourselves in this current situation was I was going to allow the amendment because this is a situation I had more questions about, and I needed to hear it from the witnesses that they planned to call, if any, to get their side of the story and their take on the situation at hand. Now, before we discuss any further, we need to. This is a moment where we're essentially about to make a precedent. Now, because this was filed during discovery after the discovery of the body cam, is the body cam allowed to be used in determining the PC for this introduction of a new charge?
for me, because it's PC was already determined for the first two charges, and now they're adding a new charge to an existing case. This is a new piece of evidence. I would say yes.
Judge
But
Aries?
it should still be subject to our review.
Yes, of course. It's still subject to our review, but Judge Aries, your opinion on the matter?
So, are we, as far as the new evidence, so to speak, is that on the ability of it being an actionable body cam, or is this some meta camera that?
This is an actual body cam. This was from the arresting officer that was in uniform. He was off duty but still in uniform, and it has the official SAST camera overlay.
Okay. As far as it being used and being able to be used within the courts, I am inclined to agree. As far as it is be able to use, however, the entirety of it, I believe that officer having the notion as far as acting on intent, to preserve life or to have the safety of life, I think would come down to whether he's on duty or off duty. He's still going to be a cop. He's still gonna act as a cop regardless. So on that basis, though, I think the cop acted correctly.
Yes. Now, what is your opinion on charge of 9/11, the brandishing a deadly weapon?
You're gonna have to refresh my memory. Who brandished? The officer?
The defendant. The officer was brandishing a firearm. The defendant, in this case, was the one that came around the corner with a knife in hand, running at the scene, and was told had to be given multiple commands to drop the knife. And after he put the knife away, he still continued to approach the officer and interdict himself into the active scene.
I mean, at that point, trying to preserve life and trying to make sure that it's correct in rightfulness, how many times did the officer shoot?
The officer didn't shoot at all.
He didn't shoot, but he told him to drop the knife over 4 times.
As far as I'm aware, nobody shot.
No one shot, but while the off-duty the semi-closed officer was taking control of the trying to take control of the detained subject to put him in the car, the defendant was brandishing a knife, approaching the scene, and the uniformed officer gave over 4 verbal commands to drop the knife. And this took place after he had left and they were taking the detained subject to a patrol vehicle to take him for booking, is when he came running back around with a knife.
Okay. I mean, you would be at fault. I mean, you're running towards an officer. What do you expect, essentially? In that standpoint, I mean...
Yeah, the issue... And the issue I have with their argument for self-defense is there was a officer in SAST uniform on scene, taking control of the scene, making the arrest, and providing orders to the off-duty plainclothes officer. This is more on the grounds of jurisdiction of the SAST officer, who's giving commands and telling the defendant to leave the scene and stop putting himself in the middle of the scene.
I mean, at that point, you're obstructing with intent.
Yeah, so that's obstructing with intent, but the question that comes into play is, because of the situation at hand, is there enough to say that he has 9/11 or not?
And to be fair, the officers weren't aware of the relations of these individuals at the time.
Mm-hmm.
Yeah, I'm still probably going to be a no on this, just because while running into a chaotic scene is problematic, I don't know that it was necessarily threatening, because he didn't necessarily approach the officer. In fact, I would tell you the officer kind of almost walked towards him more than he did the officer, because he maintained, I don't want to say a safe distance, but he maintained a distance from the officer. I don't think it was threatening in nature. Bad decision making, sure, but was it criminally intentional? I'm just not seeing it. I've watched it back 3 times. I just can't see it. Obstructing, yes, absolutely, probably.
Absolutely, yeah.
He should not be there. He should have left whenever they told him to leave. As far as the possession, if the arrest was legal, based on the obstruction, the search was legal.
Mm-hmm.
but I'm just not buying the brandishing. With with the criminal intent, I'm not buying it.
I wouldn't say it would be criminal. I mean, as far as intentions, I mean, if you go up to someone and you intentionally go, "Hey, by the way, I'm gonna, take all your money or take all your stuff or whatever."
Well, see,
that right there is a clear-cut intent. But as far as when you go into, someone
see.
turns the corner and grabs something, and then comes back with an object. Let's say that it's an object at this time, but we know it's a knife. Comes back with an object. Officer's reaction to it, I don't think it's criminal, but I do think that he had intent as far as to cause bodily harm.
Now,
see, he didn't make any threats at all. That's the biggest thing.
That's the biggest issue. But my issue here too is when he initially came into the garage, he's seen adjusting and putting something to his waistband. So my question is, what would have happened if that uniformed officer was not present at that garage? Would they just simply assault him, or were they going to stab him?
Now, see, that's just a wide view of speculation that
Yes.
does not go down right.
No. So, all right, let me finish my talking process here. So that was one of the big questions I initially had, and him having a heightened suspicion of what was going on with that situation, and then him leaving and then coming back with the knife. There's a lot of questions of like, what was his intent? If he had that knife on him to begin with, what was his intent with that knife if things didn't go the way that they had planned?
So was that question asked?
But the defendant is not present to answer, is the issue. And that's why, like, I this one I could go either way on, and I would honestly, in the situation, I would find PC just to be able to take it to trial and get the answers I seek, because I'd rather take it to trial and then drop it at trial versus not take it to trial and then the answers to those questions come up and we all come back here and go, well, shit, there was actually PC for 9/11.
I urge you not to go on a whim and find PC in hopes to get a clear answer if the answer is not clear enough. For me, and this is one of the beautiful things about being judges, is we interpret it very differently. For me, I just don't see a threatening manner. He didn't point the knife, he didn't get into a stabbing stance, he just merely ran back in and had a knife in his hand. Like, I walk around here with a cricket bat. I could take somebody's head off their shoulders at any time with it. I could run around here all day with it. I'm not threatening anybody by it. I'm just running. And if I happen to run into a police scene with it, probably bad observation on my end. But did I intend on any harm? No. Could they prove that I intended harm? No. That's the thing. Is I just, for the sake of the defendant, which we have an obligation to, I don't think we should go off of speculations of what would have happened if the uniform officer wasn't there, what his intention was. He's not here to answer to his intention. His defense attorney did not do a well job about it. It's not our job to speculate it. Our job is to go strictly off of what the statute says, whether it applies with what we have. I personally don't see it. Now, if we had an aggravated obstruction, to where just the simple fact that he had a weapon while obstructing, we don't have that statute, obviously, but if we did, absolutely, because the statute would have required a weapon to be present, whether it was used or not, but we don't have that. This is just the way that the statute is worded. I'm a no-go.
Obviously, I haven't watched the video. I'm actually more inclined to watch the video right now. Where is it in the docket?
It is.
Okay. Give me a few minutes. Let me go look.
There you go.
Hello.
Hello. We're still in deliberation.
Okay, just wanted to check in.
All right. Thank you.
Yes, ma'am.
So right now, Ares is reviewing the body
And not only
cam.
that, should I say further, I hate the wording that subsection A, draw or present a deadly weapon in a rude, angry, or threatening manner. For one, they never stated whether he was angry. Based off the body camera, I didn't hear him hardly saying anything, and when he did
No,
say stuff, it was eerily calm. I mean, rude. Come on. I don't like the wording of the statute, but based off the wording, I did not find it threatening. The officers, as far as I'm aware in the report, didn't say anything about feeling threatened, which they may have, but again, the intent of being threatening, I don't see it. I find a polar bear walking on an ice cap more threatening than what I seen in that video.
Yeah, they never said anything about feeling threatened. He said he put it away and continued walking closer to me.
In which he did not. He did not walk closer to him. I don't see it. I'm telling you, I just don't see it.
Yeah, if anything, his brother Tommy kept stepping between him,
I mean,
him
guy,
and Tim.
And he put it away. Like I said, if he meant to do some harm with that, why did he just not rush him? I mean, if this is one thing that I hate about speculations is, well, why didn't he? You know, he put it away. And then he started to walk away from the officer, walk towards him. The cop's a freaking liar. He started to walk away from the officer. And then he maintained distance. And then he put his hands up. Yeah. Not buying it, buddy. Not only that, think about this. So he puts his hands up. He's going to comply. He puts his hands up. The officer lowered his weapon. If he really wanted to do some harm, he could have pulled that knife out and stuck it
Knife out,
in his
right?
neck.
Mm-hmm.
And he didn't.
All right. Ares, floor's yours.
As far as having intent to commit harm with a knife, no. Did he obstruct? Absolutely. Did he go in continuously go through that? Oh yeah, absolutely. But on the other note, I've heard this officer curse more times than I've heard an entire bar.
He sounds like a sailor, doesn't he?
No, sailors don't act like that.
Oh, you would be surprised.
Not the way that he was talking, but regardless of that, I think, conduct of unbecoming as far as professionalism should be at least reviewed by his employer.
No, yes, I'm sure that they probably conduct that. But as for our job with this in this impromptu
No, he did
PC
not have
hearing,
intent to cause harm. Definitely obstruction, 100%.
I wish we had an aggravated obstruction because I would totally find PC for that because that was getting annoying at a certain point. But but absolutely PC on obstruction. Absolutely PC on the possession because the arrest for the obstruction was lawful. Hard no on the brandishing.
Yeah, brandishing, I don't really think so because as he asked, he did put it away. So I'm with you on that one. Although I'm gonna need a bar of soap after this court case, guys. Good God, like even just listening to it. Church? Bar of soap will do. Not the whole bar, just the half.
Stick it in his mouth and wash that mouth out with soap. Good Lord.
I'm itching.
All right. So I think with you two, both your opinions, I get where you're coming from. I see it as well. So we'll find no PC on that. Agreed?
Yeah.
All right.
I think that's definitely a unanimous decision there.
Okay. Prosecution and defense, are we both present?
Yes, Your Honor. Defense person. Yeah, both of them.
All right. First off, 9/11 brandishing a deadly weapon reads as follows. A person commits brandishing a deadly weapon when they draw or present a deadly weapon in a rude, angry, or threatening manner. B. Make gestures or hold objects to simulate possession of a firearm to instill fear. So I will start off by stating that this panel of judges has conducted a review of everything that's before us, the arrest reports, as well as made the determination that since this request to amend charges by adding this charge during pre-trial discovery phase after the discovery of the body cam footage, we found that because that happened in that sequence, it allows this court to also use the body cam footage in the review process for this PC hearing. After review of all the facts, all the evidence at hand, this court has unanimously found that at no point during that interaction when the defendant did have the knife in hand did he appear to be acting in accordance with the penal code in a rude, angry, or threatening manner. The subject came around from the trailer, brandishing the knife, yes. Running at full speed, yes. But he stopped short of the active scene and stood there. At no point did he approach or encroach on the scene any further with a knife. He was giving multiple commands to drop the knife, which he put it away, and then proceeded to encroach himself on the active scene without a weapon in hand, to the point where he did put up his hands and surrender himself to law enforcement. This court finds that at no point did he act in a rude, angry, or threatening manner while brandishing the knife, and thus we unanimously have decided that there will be no PC founded for 9/11. Judge Aries or Judge Brown, do you have any further?
I do not.
No.
With that, this PC hearing is adjourned.
Thanks, Your Honors, and thank you to the state for your time.
Well, in that case,
now comes the
overdose
fun
one
part of
bottle of ibuprofen.
having, yeah, now comes the fun part of having to type up the ruling on it in a clear enough way that Mr. Ado doesn't throw a fit.
Here's the thing, too. Piss on what he can object all he wants. That's all it is, an objection. That's the strongest thing. We unanimously agree.
3 judges agreed on the stance.
And I would say we have very different judicial philosophies. So if you can get us 3 to agree on that, that's a pretty strong case. So he can object all he wants. That's tough on him.
Okay. Well,
I mean, if you want me to write a concurring opinion to that matter for the record, I don't care to do it.
yeah, if both of you would like to write concurring opinions on the matter, and I'll add it to my document I'm going to make for ruling how we did. And then I'll add both of y'all's opinions onto it. That way all 3 opinions are on there, and all 3 of our findings are on there.
That sounds good to me. Can I send that to you tomorrow?
Yeah, that's fine. I'm gonna work on this tomorrow myself.
Okay. Perfect.
Hey, Emma?
Yes.
I'm
Guys,
wondering, I didn't see your mother at home. Do you know
You
if
wouldn't happen to have a drink, would you?
If she's out and about, or is she going? Okay. I woke up and did she fall asleep in the garage again?
Yes.
Told that woman no more sleeping in the garage. She's working on that freaking bike all day. And she falls asleep.
Actually, she's driving a van now. For right now is what she said.
Yeah, and she's not gonna like it, because I gotta either wheelchair her back to the hospital or push the van through the doors or something through the doors. Because
Oh, last I talked to her, she's up on her feet with a cane now.
oh goody. Still commanding people with toothbrushes.
She was, last I talked to her before I came up here, she was out in the garage wrenching on a van after she had to run some, she said she had to run some errands to figure out some stuff with the bank when it came to the Yellow Jack.
Got it. Okay, well, hopefully I can get in touch with her soon. Her case is mind-boggling. We'll just go with that.
Lovely. I saw that you opened up a case for her.
Yep. Sure did. But yeah. If you want to do your write-up and everything, like hearing statement and everything, I can provide that. And let me know.
Yep. Like I told Brown, if you want to write up an opinion from your point of view on this, and I'll add it to the court's official ruling, and I'm gonna let them know right now that they'll have the docket for the court's official ruling within the next, I'd say, 12 hours. Just because it's been a long evening, and I'm sure everyone wants to go get some rest.
Yeah, I would think so.
CC. James Jones at Brown. Alex M. Emma Bliss. All right, sent that onto the docket. Okay, that has been sent over onto the docket. And then we'll get that taken care of, and I'll get that to them. And then once I get them that, we will discuss availabilities for court. Looks like James Jones and most of the defense won't be available until next week. So it looks like the trial will be. I said it looks like James Jones and the majority of the defense will not be available until next week. So it looks like the trial will be next week.
For what?
For this case.
Okay.
Yeah, this case is already at trial, so it's ready for its trial. So once I give them the full detailed ruling for this PC, I'll work with everyone to figure out schedules to get that scheduled. But I know James Jones is out of state until next week.
Okay.
All right. I'm going to go to sleep. Good night.
Good night.
He's not law enforcement.
Oh dear lord.
I will go get my cruiser out of the garage.
Oh, goodness gravy.
That sounds like you're having fun in there.
Well, this case is back on the dock and going to trial.
Woo!
Ugh.
Good lord. When's that set for? Are we not got a date yet?
It's probably not going to be until next week, because it sounds like that's when most of the defense will be available, is next week.
Perfect. I should be around.
Okay.
I did the diligent duty of watching the stairs.
Yeah, I saw you up in the balcony.
Well, I went up there just to kind of see if I could hear and listen. I also walked around outside to make sure no one could hear through the building, you know? Try to listen through the windows.
With our paper-thin walls.
I think this one's better than the old courthouse. The old courthouse you could probably hear halfway across the state.
Yes. What's that?
I said it was very paper thin.
Yeah.
But don't worry, this one did an amazing job.
I did my best to keep everyone safe.
She patrolled the halls, everything.
Very good, very good.
And then when you guys had your actual PC here, and I just stood at the bottom of the stairs, and no one came in.
I'm so proud of you.
Yeah,
Yay!
yeah, good job.
Head pets.
Good job. What's wrong with your badge, though?
Yeah, can't fix that. It's no issue.
Okay, well, you guys enjoy your night.
Oh.
Will
Yeah.
do my best.
Or morning, or, evening. Looks like it's evening.
I think it's...
I think it's morning.
Oh, it's,
I think it's
yeah,
morning.
we were here too long.
Yeah, you gotta love night court. Woo!
It's the best.
Hell yeah.
Oh man, what a day.
At least it sounds like it got settled and things are progressing the right way.
Yep. did you hear the precedent that was set?
Not really. I was skating out in the hallway, so it was kind of hard to hear.
I wasn't talking to you. I was talking to him.
President. I always get that word messed up, Your Honor.
The PC precedent.
Yes.
It's like president, but you precedent.
So president.
President. God damn it! Now I'm messing up. Anyways,
President.
Sorry, Your Honor.
so if an amendment of charges is introduced during discovery phase, anything that has been submitted to discovery prior to the request for amendment of charges is usable by the courts to determine PC.
So basically, okay, so if I understand this correctly, the state can amend charges. There has to be a PC hearing for that? The new charge?
That's going to be discussed amongst the judges. We got to figure that aspect of it out. But they both agreed to have an impromptu PC in regards to it. So,
Tonight, yeah.
with how messy this case is, I was like, fine, we'll have it. Jesus.
Yeah, no, that I was just sitting there. It was like, oh my goodness.
Yeah, this case has been going on since last month.
Yeah, I have a case like that. My client doesn't want to, give. I understand.
Yeah, you understand the messiness of these. So,
and having a case that goes like more than like a couple weeks, it gets really messy.
yeah, so as of right now,
It's not a couple of years.
the current precedent until
See, look, you just said president.
yeah. Anyways,
No, she said precedent.
the current ruling by the courts until the judges panel the judges convene for a conference on the matter is if both parties agree to have a PC hearing on it, then we will. But any evidence that's already been discovered, I guess at this point, yes. Until said otherwise, we'll have a PC hearing if a minimum charges is introduced.
Yeah.
I guess to make it simple, yes. There'll be if an amendment of charges is introduced during the discovery phase, then we'll have a PC hearing. But all evidence has been discovered up to that amendment request will be included. Now, at the end of the day, it is still the court's discretion on if we're going to accept the file to amend charges or not.
Okay.
So if we accept their filing to amend the charges, then we'll have a PC hearing and so on and so forth, or we could deny it. And it's so if
in the event that, not to interrupt you, Your Honor, but in the event where like the state is just gonna have to like refile the entire case with the new amended charge, or
no, it's like this. So we already had a PC for this case, right?
yeah,
And then during discovery, they filed an amendment to add a charge. So if during discovery they file a request to amend or change out one of the charges,
okay,
then we would have a PC to determine if there's probable cause for that charge. Yeah.
Charge them all, I say. Charge them all.
The only time that they would have to, the only time that they would have to refile is if they dismiss the case without prejudice, and the without prejudice is granted, and that docket closes, and if they want to recharge the person, they have to open a completely new docket for it, and at that time they can add any charges that are applicable to the arrest. But at the end of the day, it goes through the process from the beginning, so there has to be a PC hearing and so on and so forth.
yeah. Man, it's gonna be a crazy time.
Oh, yeah.
Only the best of times.
It was the best of times. I say it was the worst of times.
Always.
Your Honor, I feel like there used to be more judges.
Bo is missing. But Bo is busy with out-of-state obligations.
Well, wasn't there Judge Carter?
We don't talk about Bruno.
We don't talk about Bruno.
Bruno?
I guess he's never seen... I guess you've never seen that Disney movie.
Who's Carter? I don't know a Carter.
We don't talk about Carter. Apparently he's a bailiff now.
What?
Yeah.
I don't know what
about,
he is.
What about Mrs. Adriana Rose, I think?
Oh, she's been gone for a long time.
Well, she came... Didn't she, like, come back and become a judge, and now we haven't seen her again?
Oh, did she? I don't know. I haven't seen her. Last time I knew, she left state after her... She left state in the middle of her mayoralship. Or at the end of her mayoralship.
And let nobody know?
I didn't know she came back.
Yeah.
Yeah, I she's in the phone as a judge, and I'm like, huh? Last time I ever seen, she was a district attorney, and then poof, after becoming a mayor.
Yep. So I don't know about her.
The other one decided to say goodbye and never return.
Yeah, Caleb Label goes to the DMs. Yeah, so that's it. It's me, Hunter Brown, Jay, Aries, and Bo. So there's 5 of us.
I was going to, but obligations stated otherwise. Makes me sad. I don't see why.
You already know my opinion on that.
I mean, I get where it's coming from. I do. But here's the sad thing. The amount of power some people hold while they're just working.
All right, well, that's a conversation that we don't need to be involved in. All right, well, that's where we're going to wrap up this episode of DoJLife. 1076 is finally going to trial. Thank God. Like I said, this has been going on for a month. So thanks for hanging out with us. Put in the hard work, because one day it'll pay off, and we'll be back one day. Take care, everyone.